Hello and welcome to the final webinar of our series on dispute resolution within the construction sector. Today's webinar focuses on mediation. I guess this can be described as a back to basics webinar series where we intend to provide a comprehensive overview of each method and discuss the practicalities of employing each as a means to resolve disputes. Before we begin, I've placed you all on mute to minimise background noise. If you would like to ask a question, please do so using the button on your screen and we will reply to you once the webinar has concluded. I'm Chiara and I'm joined by Natasha. We are both solicitors in the construction and special projects team, specialising in construction and infrastructure dispute resolution. Our team regularly advises on construction contract issues and disputes across a range of projects and clients. Mediations are a common occurrence for our team, and it is this experience that informs what we're going to share with you today.
We will begin today with a brief overview of mediation, covering the background and how a typical mediation would be conducted. We will then move on to discuss the advantages and disadvantages of mediation and consider when it should be introduced and how. We will conclude by offering some strategic advice on how to use mediation to your best advantage. So firstly, what is mediation? At its core, mediation is simply a facilitated negotiation. It has been around for centuries, but began to gain popularity in this context in the mid-1980s. This came as part of the wider attempt to explore alternative means of dispute resolution to ease the pressure on the courts. The legal community at large soon began to recognise the potential of mediation, and organisations were set up to promote this new method. An early example was the Centre for Effective Dispute Resolution, or CEDR, which was founded in 1989. Mediation has slowly gained in popularity ever since. There is no fixed definition of mediation, but it is best understood as a form of dispute resolution in which a neutral third party assists other parties to work through a negotiated settlement of their dispute. A typical construction mediation would occur over a few days, with an independent mediator appointed by agreement between the parties. Usually the parties would meet at a venue which has space for each to hold their own private discussions, as well as a bigger space for the mediation. In the current climate, this can be achieved virtually by the use of video conferencing technology, with breakout rooms used for private discussions. In advance of the mediation, parties will exchange position papers and documents and have a brief consultation with the mediator. This helps identify the key issues and ensures that the mediation stays focused on the essential aspects of the dispute. The mediator will formally open the mediation with a plenary session, providing an overview of the procedure before allowing each party to make an opening statement to outline any points of particular concern. The mediator will then facilitate a discussion, either in a joint forum or separately, as well as holding private discussions with each party to understand their position and possible compromises. The overall target is to reach a settlement between the parties. Mediation generally has a high success rate. Mediators who responded to the CEDR's most recent mediation audit reported that just over 74% of their cases settled on the day, with another 15% settling shortly thereafter.
As we have just explained, mediation has a very high success rate, which has a benefit in itself. This figure is perhaps less surprising when you consider the fact that mediation is a voluntary process, and so parties are generally only likely to agree to mediate where they believe that a settlement could be reached. However, there is a more cynical reason to engage in mediation. Mediation may be useful as a fact-gathering exercise to scope out the position of the other side and prepare accordingly for the next stage in the dispute resolution process. Mediation is typically cheaper than other forms of dispute resolution. Although parties will incur costs preparing for and engaging in the mediation, this is likely to be far lower than comparable costs in, say, a court action. Indeed, the cost of alternative action is something which the mediator will ask the parties to consider, as that sum alone will bring the parties considerably closer together in terms of reaching a financial settlement. Specialist mediators are often experienced dispute practitioners and parties can expect to pay between £3,000 and £8,000 a day for their services, depending on the level of experience and the number of parties involved. This is usually payable equally between the parties up front and is likely to be a fairly proportionate cost when considered in terms of each party's internal costs in a reasonable sized dispute. This makes mediation an easy sell to both parties. Why not attempt mediation when there is, relatively speaking, so little to lose? Parties to mediation are able to choose a mediator best suited to their specific dispute. This allows them to make allowances for any unique challenges. For example, choosing a bilingual mediator to address language barriers between the parties. Mediation allows disputes to be concluded relatively quickly. This reduces actual costs, but there can also be value in allowing the parties to sort out their dispute and move on. This is especially prudent given the current workload of the courts. Proofs in the Court of Session were being fixed 2 years in advance, and this was before the backlog caused by COVID-19 pandemic, which some commentators have predicted could take many more years to clear. Avoiding this drawn-out process can be of value in itself. Linked to this is the benefit to the relationship between the parties. Many parties to a construction dispute will initially have good working relationships, but these can often turn sour as the proceedings continue, especially if the proceedings are adversarial. The collaborative and sensitive nature of mediation helps to maintain the relationships between the parties and can sometimes see relations even improve once the parties have taken the time to appreciate the perspective of the other. Mediators are likely to ask the parties to consider the cost-benefit of maintaining a working relationship and asking that the parties factor that into their settlement calculations. We can see that there's a theme here. Most of the benefits of mediation have a cost benefit attached to them, which can be a significant factor when considering settlements. Despite its modest cost and short time frame, mediation is still an appropriate forum for resolving all aspects of a complex dispute. This can be contrasted with other dispute resolution mechanisms which proceed within a short time frame, such as adjudication, where a large complex dispute should be broken down into more manageable pieces. Mediation allows the parties to retain a degree of control that they do not have in other methods of dispute resolution. Parties retain control over the decision and settlement of the dispute instead of handing over that control to a judge or an adjudicator, for example. This can be powerful in that each party is forced to consider the other side's position and point of view in more detail than they may otherwise have to. Parties are also more likely to be satisfied with whatever result is achieved as they had a hand in deciding it. This may not be the case where control is handed over to a third-party decision maker, even though the end result may be similar, which we see often in adjudication. This degree of control is also reflected in the flexibility of solution that can be achieved. Parties are free to agree and settle as they wish, meaning that creative and flexible solutions can be considered. This can be contrasted with the limited scope of legal remedies available to the court or in arbitration, which may be inappropriate to resolve the wide range of business or commercial issues which may arise. We've seen mediations where one party really just wants an apology or an explanation from the other side. This is not something that would be handed down by judgment. Settlements can be about more than just money. Commonly, mediation results in repair works or information and document provisions. Sometimes it can lead to new business opportunities or the restructuring of old relationships. Being in control of the decision and the flexibility it affords means that parties are more likely to get what they need to conclude the dispute. Even if mediation does not result in settlement, the parties are likely to have benefited from the process, either by narrowing the issues in dispute, testing the strengths and weaknesses of their case, or having had the opportunity to listen to each other's views. A final important advantage of mediation is that it is a confidential process. Mediations themselves are conducted under confidentiality agreements, meaning that discussions can be open and are entirely on a without prejudice basis. If the mediation does not conclude in a settlement, both parties can leave without the mediation affecting their position in any formal process. If a settlement is reached, then the terms of settlement will also be confidential. It is likely that all parties will see the benefit of keeping the dispute and settlement out of the public domain, especially in situations where the dispute is commercially sensitive or controversial. The importance of confidentiality to the process was underlined by the English case of Pharmacist Limited against Secretary of State for the Environment, Food and Legal Affairs, in which a confidentiality clause was implied into a mediation agreement in the absence of any express provision to that effect. It was adjudged that the only exception to confidentiality is where it is in the interests of justice to allow disclosure, an exception that is only exercised in exceptional cases.
Now, this all paints a very favourable picture of mediation, but like any method of dispute resolution, there are some drawbacks. Many of these are the inverse of the factors we have just mentioned. The fact that mediation is a voluntary process can also be a disadvantage. Parties cannot be forced to sit down and mediate. Even during the process, for example, parties can walk away at any time. Having said that, if parties were reluctant enough to consider abandoning the process, then it is unlikely that they would have reached a settlement in any event, and so forcing them to be there at the mediation would be of no benefit to either party. There is a growing body of case law in England in which parties are penalised for unreasonably refusing to mediate at the beginning of their dispute. The defendant in Reid v Buckinghamshire Healthcare NHS Trust was ordered to pay the costs of the claimant from the date on which they had received the offer to mediate, which they then unreasonably refused. Although this has been interpreted as the first step towards mandatory mediation, the only concrete difference that parties in England should now be prepared to justify their reasoning at a later point in time. No such body of case law exists in Scotland, but that is no doubt a result of the fact that the court rules contain little reference to mediation. Should there be any future development in this area, it is likely that the English approach would prove influential. Costs can also be a drawback of the mediation process. If the mediation ends unsuccessfully, the costs incurred, although reasonably low, are still payable in addition to all of the other costs of progressing the dispute. Mediators' fees are usually paid up front and equally between the parties. Unsurprisingly, there is no cost recovery from the other side unless that is the agreed part of the settlement. However, it bears repeating that this drawback can be used by the mediator to encourage reaching a settlement. The confidentiality of the process can also make it less appealing for some parties. Although most commercial organisations will appreciate the privacy, some organisations will want their day in court in the hope that they will be vindicated. If parties are seeking a ruling that they were right and that their opponents were wrong, they may be unsatisfied by the conciliatory nature of mediation. A current drawback is the perception that an offer to mediate reflects a lack of conviction in one's case. Some parties are reluctant to suggest or recommend mediation in case it sends the wrong message to the other side. However, this flows from current attitudes towards mediation rather than from actual mediation itself, and it is clear that attitudes towards mediation are changing. Experienced parties know that disputes are rarely cut and dry with fault only on one side. This rings true in a construction context, where disputes are complex and often involve esoteric technical issues. Mediations are not simply a forum where both parties set out their position and meet in the middle. It is an opportunity to present your position and analyse that at the other side. If proposing mediation suggests to your opponent that your case is weak, when in fact it is not, the strength of your case will become clear through the course of the mediation.
Thanks, Natasha. So before we look at our tips and strategies for mediation itself, we'll offer some thoughts on when mediation should be used and how to introduce it to a dispute. Like any method of dispute resolution, mediation should always be part of an overall strategy. We noted in our last webinar that adjudication should be used as a means to an end rather than an end in itself. For mediation, the opposite is true. It is a good way to end a dispute, but if parties are clearly a while away from being able to settle, it might not be the best option. When a dispute crystallises, each party will consider its position, then entrench themselves in that position. This is not conducive to good mediation. Instead, we would recommend that parties start some other proceedings first to flush out the key issues and allow the parties to see to the crux of the dispute. So looking at a complex dispute, an adjudication could proceed on a discrete aspect such as an extension of time claim or a loss and expense claim and set out some boundaries for the dispute. This could then lead to mediation on the overall final account, which might have been impossible to mediate while there were extension of time or loss of expense claims on the table. In a similar vein, court proceedings should be useful to make the parties articulate their entire position and provide documents and vouching to support that position. This could help both parties to better understand the other party's position, which will help to evaluate the possible successes and outcomes of the dispute. That information and knowledge gained may be sufficient to bring the parties close enough together to consider mediation. We would therefore generally recommend that mediation is only considered once parties have a very good feel for each other's position and are at least open to the possibility of settling the dispute. It's also important that parties approach mediation with the right attitude. Mediation will only be effective if the parties are prepared to be realistic about what it will take to resolve the dispute. Anyone with experience in dispute resolution will be aware that there are very rarely clear winners and losers. Even a party which wins its case and has its cost awarded is still likely to have unrecoverable legal and internal costs and to have invested considerable time and energy. Parties should keep these commercial realities in mind while conducting mediation. Both parties should also be ready to listen to the other side, which again might be more difficult right at the start when the issues in dispute are still raw.
Thanks, Chiara. So now we will move on to discuss some tips and strategies that could help to mitigate the drawbacks and maximise the benefits of engaging in mediation. The first of these is to carefully consider the timing of the mediation. Mediation can take place at any point in the lifespan of a dispute, but choosing the opportune moment will ensure that it is cost-effective and more likely to be successful. Opportunity here is calculated differently than for other, less flexible methods of dispute resolution. It is best calculated by pragmatically assessing when each party will be ready and receptive to mediation. External factors may also influence timing. For example, a mediation clause in a contract may stipulate that parties must attempt to reach a settlement through mediation before any other further proceedings can take place. Choosing the mediator is another important consideration. Parties shouldn't reject a mediator just because they are suggested by the other side. Bias is not as important a consideration as it is the parties themselves that choose the settlement. If one of the parties has had a positive experience with a mediator, this should be seen as a positive rather than a point of further dispute. This being said, obvious conflicts of interest should be avoided, and you are well within your rights to object should this be the case. Again, given that the mediator is not a decision maker, it is not as necessary that they have an in-depth knowledge of the subject matter, but more that they can demonstrate an understanding which will be beneficial when dealing in a highly complex area. In such complex disputes or where there are multiple parties, it can be useful to employ an assistant mediator to ensure that things run smoothly. The next consideration is the choice of venue. Neutral venues will cost more, but it may be preferable to hosting the mediation at either party's office. In addition, practical considerations include the availability of Wi-Fi, printing facilities, and the physical location of the rooms. In this current climate, remote mediation negates some practical considerations, but throws up its own challenges. It is important to ensure that each attendee has the necessary IT facilities to attend the mediation and also the necessary technical know-how to choose the chosen video conferencing platform without any issues. Recognising these new challenges, the Civil Mediation Council has issued guidance on engaging in remote mediation. This highlights the importance of security measures, such as ensuring that any file sharing facilities or video conferencing platforms have the requisite data protection procedure and privacy notices in place in order to preserve confidentiality that is such an important part of the process. Specifically, the guidance also asks mediators to ensure that files and other confidential information will be removed from these systems after a specified amount of time. Furthermore, the mediator may have to be more forthright about confirming ground rules at the start of the process. The fact that people are attending from home might make the process seem more casual, but it is important that this casual attitude does not extend to parties' need to ensure confidentiality. The guidance finally also asks mediators to consider the impact of this technology on the relationships between participants. Mediation relies on good interpersonal relationships being forged between the parties in the course of coming to a settlement. With participants attending remotely, that rapport takes longer to gain and can disappear more quickly. When communicating via screens, it is somewhat harder to pick up on slight nuances of behaviour that could give away how a certain party is feeling. However, a slight advantage could be that it is easier to watch a single person to see how they react to a certain line of discussion, which would probably be quite impractical and fairly awkward to do in person. It is vital that both sides come to the mediation with people who have the authority to settle. There is nothing more frustrating than finally reaching a solution after days of negotiation, only to hear that, "We'll pass this up the chain and get back to you." Most trained mediators will make sure that authorities are in place in advance to avoid this happening, but it is something that parties should bear in mind when deciding who should attend on their behalf. This problem commonly occurs when dealing with the public sector, as council officers may not automatically have this level of authority. However, we have acted both for and against the public sector in mediation and know that it can be made to work. As part of their preparations, the public sector party will have to consider a full range of possible settlements and seek advance authorisation to settle within that range. This will allow those attending the mediation to conclude on that basis. In essence, there is no difference from a private sector party deciding its top line and bottom line in advance. Parties should carefully consider who should attend the mediation on their behalf. It is useful for those who have been most heavily involved to be present, as well as any experts, to ensure that parties are fully prepared to discuss all relevant aspects of the dispute. It will also be helpful to have those involved tell their side of the story and add any colour that might not otherwise be conveyed by a witness statement, for example. This should be balanced against the suitability of that person's character to the mediation process. For example, are they robust enough to stand up to the arguments of the other side? Conversely, are they too robust and unlikely to keep a level head while making their case? A single unsuitable attendee can alter the mood of the entire mediation and may jeopardise a potential settlement. We would always recommend that both parties' positions are set out in writing beforehand and that relevant documents or a joint bundle are circulated. At the very least, this will be useful information for the mediator. It can also be useful for the parties to see the position of the other side distilled down to its simplest format and to see what issues the other side considers important enough to include. Parties should make the most of their opening statements too, focusing on delivering your key messages and addressing what you perceive to be the issues most important to the other side. These set the tone for the rest of the mediation, and so parties should try to appear reasonable and conciliatory. Throughout the mediation, parties should try to focus on either side's interests and outcomes rather than your entrenched position. Mediation is an opportunity to evaluate commercial interests and see whether they can be best served by a settlement. Once the factual and discursive part of the day is done, hopefully the parties will get to a position where a settlement does seem possible. At this point, parties should consider their negotiation strategy. For example, should they make the first offer? And if so, what should this offer be? And what non-financial elements are part of the consideration? A good mediator will assist in the negotiation, but ultimately it is for the parties to consider all applicable factors and to decide their own approach. Non-financial elements are, as mentioned earlier, a key benefit of the mediation process. It is important that parties don't lose sight of these throughout the process. There may be an assumption that once the numbers are agreed, the lawyers will be left to draft the rest of the settlement. This, however, runs the risk that some seemingly trivial piece of the settlement is actually a deal breaker for the other side and puts the whole process at risk. It is best practice, therefore, to ensure that everything is discussed, financial or non-financial, and therefore considered in the process of reaching a settlement. Finally, should a settlement be reached, it will need to be documented. Each side's advisors are likely to have drafted skeleton settlement agreements in advance. to be populated on the day. Provided that the details have been agreed, this should be a relatively painless part of the day. Settlement agreements are signed there and then, and the dispute is considered closed.
Thanks, Natasha. We have now reached the end of our presentation, and we hope this has been an informative look at mediation in the construction sector. If you would like to ask any questions, please do so using the button on your screens, and we will get back to you shortly with our answers. A recording of this session will soon be made available should you wish to go back over certain points or share it with any colleagues. This also marks the end of our webinar series, which we hope has been a useful guide through some different methods of dispute resolution that could be used to resolve any construction disputes. Thank you all for listening, and we hope to see you at our next series.